Good evening, and thank you for joining us today for our latest FedSupport series webinar. My name is Jenny Mattingley, and I am the Vice President of Government Affairs at the Partnership for Public Service. For those of you not familiar with the partnership, we're a nonpartisan nonprofit working to build a better government and a stronger democracy. And we do that through policy advocacy, leadership development, workforce programming, and convening leaders across organizations and sectors. And the most tangible impact is seen through our support right now for the federal workforce. We've been sharing resources, providing plain language explainers, amplifying stories of the incredible work that you and that your federal employee colleagues do for our country every single day. So I always like to start these by thanking you for your service. So thank you for the work that you do. I do want to share a few notes before digging into today's conversation. Throughout the webinar, we will answer some questions that you submitted during registration. You can also submit a question anonymously through the Q&A function, and we will do our best to address all of those questions as we go, but we may not get to everything. Given the complexity and nuances of the topics we're discussing, we may not be able to answer every question tonight, and we're specifically focused on some of the legal cases and the landscape out there. But we will continue to hold webinars, and so if there are other questions that you have that didn't get answered, please let us know. If you miss any of this webinar, you want to revisit it or share with others, it will be recorded and posted on our FedSupport.org hub, and we've got other recordings out there as well, and that should be up there relatively quickly. And I think Shirley, who is my colleague helping produce this webinar tonight, will be putting this link for the FedSupport.org in the chat, as well as some other links throughout that our guest Craig is going to share with us. Finally, while this discussion is geared towards federal employees and those recently in federal service, it is an open forum, and we may have folks joining us for other communities, but we really are focused on what's impacting the federal workforce tonight. And before we kick things off, a disclaimer: the content provided during this session is for informational purposes and is meant to provide an overview of recent events and offer suggestions for helpful resources. What you hear today is not intended to be legal guidance. And as you'll hear, if you require any legal advice, we do recommend consulting with a qualified attorney. And we will talk a little bit about the Federal Worker Legal Defense Network, where you might be able to find some resources. With that in mind, I would like to introduce our guest tonight, who will talk about the legal landscape, we'll answer some questions, and we'll just do a little bit of back and forth. So Craig, thank you for joining us so much. You are here from the AFL-CIO, and would love if you could just introduce yourself briefly and tell us a little bit about who you are, where you're at right now, and then we'll dive into the conversation.
Great. Well, thank you very much. It's my pleasure to be here. I want to thank you, Jenny, the partnership, and of course, all of you who are listening tonight. And I want to just echo Jenny's thanks for your service, and really my apologies for how you're being treated at the present moment. As Jenny said, I am senior counsel to the AFL-CIO, and as we'll talk about more later, I'm also special counsel to Rise Up Federal Workers Legal Defense Network, and we'll get into that more, what exactly that is, and how you might utilize the network later. But why don't we jump right into the subject? And if I could get the next slide. So Jenny has asked me just to provide a broad overview of the current litigation, and we recognize that that is both incredibly complicated and changing every day. So I want to just start with talking about the litigation broadly without talking about any piece of litigation, and then proceed to kind of take categories of litigation and explain what's going on in each category. So first of all, who are the parties to the litigation that's being brought? They really fall into the categories I have there on the slide. The parties are unions, the unions that represent federal employees, AFGE, NEFI, NTU, AFSCME, and others. They're also the consumers of government services. That is, it's not only federal employees who are being hurt by what's happening, it's also all of those who consume their services, whether those are people on Social Security, people who go to the national parks, et cetera, et cetera, et cetera. And then the AGs, particularly in the blue states, of course, have also been very active in protecting their states, which of course interact with the federal government in numerous ways, and citizens in their state who also benefit from all the services that federal employees provide. So those are the plaintiffs. Where are the cases being filed? Answer: all over the country, above the Mason-Dixon line. So there is, of course, a little bit of strategy going on here. And the strategy, of course, is to try to file in places where the parties think they'll get the fairest shake from the judges. So most of these cases are being filed in the District of Columbia, New York, Massachusetts, Rhode Island, California, and similar states. Just as under President Biden, the red state AGs filed principally in Texas. So all over the country, but largely above the Mason-Dixon line. What happens when these cases get filed? Cases get filed, and they are, by and large, they proceed on a very expedited basis. So ordinarily, the first step of the plaintiff soon after the case gets filed is to move for what's called a temporary restraining order. Right? So the injury here is very immediate. People are about to be fired. The recipients of those services are about to be deprived of those services with potentially catastrophic results in the case of, say, health and safety agencies. So plaintiffs typically proceed very quickly to ask for a temporary restraining order. That can be issued almost immediately by the court after a hearing without any substantial trial, often without any substantial submission of evidence. Just typically declarations, affidavits, and sworn statements about what's going on. That's typically followed by what's called a preliminary injunction, which is also issued prior to trial, but on a slightly more extended schedule by a court. What's happening in almost all these cases is if those orders are issued, if a temporary restraining order or a preliminary injunction is issued in the trial court, the government immediately goes to the Court of Appeals and asks for a stay, right? So trial court, say the district court in the District of Columbia issues a preliminary injunction, government immediately goes to the DC Circuit, the Court of Appeals, and requests a stay. Again, on a highly expedited basis. So absent the usual scheduling, briefing, argument, decision, often within a matter of days, stay is either granted or denied. And then typically, government, if the stay is denied, goes to the Supreme Court and requests a stay there. This is the so-called shadow docket, a term you've probably heard. That is a docket which doesn't include full briefing and full argument, but where the court is issuing orders on this very expedited basis. So
and Craig, can I jump in with a question, clarification right there on those? Because this might be something I know I've heard from folks. When you're talking about just typically, not specific to these cases, but an injunction or a stay, for instance, if you get a temporary restraining order, there's a court case, does that stop the government then from taking the actions it was taking, is basically what those things are saying. And then the stay would reverse that restraining order and allow the government to continue its actions.
Exactly, you've got it. So preliminary injunction, temporary restraining order, as the term suggests, they're ordering the government to stop doing something, right? The stay is to halt what the court has ordered. Now, whether the government actually complies with those orders, as you all know, is another question. But in many of these cases, the employment cases, the government is complying. So initial orders, if the plaintiffs are successful, stop the government's action unless they're stayed by a higher court. Unfortunately, although this litigation is proceeding very quickly on a preliminary basis, final decisions are a long way off, right? So we may have in these cases already orders from the trial court, Court of Appeals, and even the Supreme Court, but those are not final orders, right? Those are preliminary orders pending full adjudication. So eventually, these cases are going to be decided on a final basis by trial courts, on a full briefing and argument basis by the courts of appeals, and then many of them will probably go to the Supreme Court. Right? So a final decision in these cases, even though the litigation is currently fast and furious, is unfortunately quite a ways off. The court will probably take some of these cases in the fall when its next term starts in October. They'll be briefed, they'll be argued, and probably final decisions are deep into next year, if not the following year. So we are looking at uncertainty for some considerable period of time here. So if I could get the next slide. Hold on that slide for a second. So there's one common argument I want to just address, and it explains a little bit why employees are not the only parties in these cases. So one of the arguments the government is making in all these cases in the federal courts is that they shouldn't be in federal court. Right? The government argues that there's a doctrine called channeling, that is, the cases should be channeled, pushed into the agencies. That is, Congress has created a system governing federal employment, and it's created agencies to hear complaints or appeals within that system, principally the Merit Systems Protection Board, which we'll talk a little bit more about later. And so the government argues in most of these cases, plaintiffs can't be in federal court. Their essential argument is about what's happening to federal employees, and all of those complaints and appeals should be channeled through the Merit Systems Protections Board. And that's why the AGs play an important role, because they're not federal employees, and the consumers play an important role because they're not federal employees. And yet the government continues to make this argument in all cases. It's a problematical argument for the reasons we'll talk about later, because right now the administration has also decapitated the Merit Systems Protections Board, firing members such that the board does not at the present time have a quorum and can't, at least at the highest level, proceed. So let me take the next slide. So I'm going to give you the categories of types of cases that are proceeding in the federal courts. And the first category arises out of what happened almost as soon as President Trump took office. That is, they began to dismantle agencies in their entirety. Right? It started with the USAID and the CFPB. As Elon Musk proudly proclaimed in February, quote, "We spent the weekend feeding USAID into the wood chipper." And it's proceeded to other agencies, Voice of America, the FMCS, NIOSH, and others. These are agencies, as you all know, that are created by statute. That is, the president didn't create these agencies. Congress created the agencies and mandated that they fulfill certain functions, providing aid in other countries, protecting occupational safety and health, etc. So the president cannot unilaterally simply shut down these agencies. And that's what this ongoing litigation is about. So in all these agency dismantling cases, the plaintiffs argue that the RIFs or the firings or whatever the administration has done to essentially shut down the agencies is inconsistent with the statute. That is, the agencies have a congressionally mandated function, and the president cannot, through his unilateral action, prevent the agencies from fulfilling that function. So agency by agency litigation arguing that the executive's actions are inconsistent with the congressional mandates. And we've had some success and some failure. So we have a preliminary injunction that's been issued as to the CFPB. We've had a preliminary injunction that's been issued as to the Department of Education. A motion for preliminary injunction is currently pending as to HHS, brought in a case brought by Democratic AGs. So agency by agency litigation. But there is a broader piece of litigation as well, if I could get the next slide, which you may have heard about, which was initially brought in the Northern District of California, where the theory is an across-the-board theory, that the president, in order to take the actions mandated by his executive order and which are currently being carried out in all these agencies, the president is attempting to reorganize the federal government. And that requires congressional authorization. So in fact, there is a statute which allows Congress to authorize the president to reorganize the executive branch. President Trump, in fact, requested such authorization in his first term and didn't receive it from Congress. So there is a statute. It permits the executive to reorganize, but it requires affirmative authorization by Congress. So that's a theory in this case that was brought in the Northern District of California, that this across-the-board action in all the departments and agencies by the executive pursuant to President Trump's executive order is a reorganization which is not authorized by Congress. So a violation of the separation of powers. The district court in the Northern District of California agreed and issued first a temporary restraining order and then a preliminary injunction. According to the procedure, which you now all understand, the government went first to the Court of Appeals, the Ninth Circuit, and requested a stay. The stay was denied. They've now requested a stay in the Supreme Court, and it's currently being briefed, with the plaintiff's brief being due on June the 9th. So right now, as we understand it, most agencies are complying with this order and informing employees that the RIFs are currently on hold pursuant to this court's order. We understand that there's some disputes going on in a few agencies, education, HUD, and state, which are either subjects of discussion between the parties or being brought back to the court in San Francisco. So
and Craig, can I ask a quick question, jump in? As you're talking about the reorganization case, we had a question come in about, does this claim of reorganization apply to all the agencies on the previous slide, or is it only certain agencies that are impacted by reorganization claims in this litigation?
Not every agency was named in this case, although most of the large departments and agencies are covered. And I'm going to give you some places where you can look to get more information as we proceed here. So let me have the next slide. So as you all know, what's also happened here is that the administration has tried to make work as unpleasant as possible and used rhetoric that's as insulting and degrading as possible in order to get people to resign. So they're not only trying to fire people, but they're trying to get people to resign in various ways, forcing people back to work in the office 5 days a week and other means. And then everyone got the so-called fork in the road email. That was the subject line of the email, and said, among other things, quote, "At this time, we cannot give you full assurance regarding the certainty of your position or agency." So this was a veiled threat saying your employment might not exist tomorrow. In fact, your agency might not exist tomorrow. So why don't you leave? The email offered to permit employees to take a deferred resignation, allowed them to continue to be paid until the end of September while not having to work. The offer had no foundation in law, no appropriation backing it up, and it was followed by a series of confusing issuances from the Office of Personnel Management. It's not at all clear the offer and acceptance are enforceable. But of course, many employees did take it given the current situation. The fork offer was challenged in a case brought by AFG-E and AFSCME and other allies in Boston. It was originally enjoined, but the injunction was subsequently lifted on this channeling ground, on the grounds that the case should have been brought before the MSPB. But the case continues. So the challenge to the fork continues. The fork offer and subsequent offers by agency have included a broad waiver of rights. So employees who accept the fork offer or subsequent offers for deferred resignation do agree to a broad waiver of rights. That is a right to bring other types of challenges to what's happening here. If the monetary aspects of the offer and acceptance are not complied with, there will likely be an opportunity to pursue a remedy, but it will be before the Federal Court of Claims, which has a fairly extended statute of limitations. So that's the fork in the road situation. If I could get the next slide.
Oh, and Craig, one question just came in for clarification before you jump into that. One about what does the term enjoined mean?
Okay, so enjoined could mean either of three things. One is a temporary restraining order. So that's the very initial action that a trial court could take on a very expedited basis. A temporary restraining order enjoins, that is, stops the action, whether it's a RIF or whether it's this offer of a fork in the road email. So it stops the action, it enjoins the action, but initially the temporary restraining order is supposed to last no longer than 14 days. So very brief order. It can be followed by a preliminary injunction, which can last all the way until a full trial. So that can last a longer period of time and is typically issued or denied after a fuller briefing and argument. And then you can have a permanent injunction. So the ultimate outcome of some of these cases, say the government reorganization case, could be a grant of a final injunction. The administration cannot carry out this reorganization without congressional authorization. So you could have a temporary restraining order enjoining the government's action. You could have a preliminary injunction enjoining the government's action until trial, or you could have a final injunction preventing the government's action until it's overturned on appeal. So
Great, thank you for that.
So somewhat proceeding in chronological order here. The next thing the administration attempted to do was what we think the administration thought was the low-hanging fruit. That is, let's just fire all the probationary employees since they have lesser protection. And so instruction went out from the MSPB to all the agencies, essentially fire all your probationary employees. So it's really cutting off the civil service system at its roots. All those people who are coming into the federal government, wanting to serve their country, all being fired at the same time. But because it was carried out in such a rushed and reckless manner, it generated two federal court actions, one by Democratic attorney generals in the District of Maryland, and one by unions and other allies, again in California, and then a whole set of class appeals, agency by agency at the MSPB. And there were various theories. The theory in California was the decision to fire probationary employees is lodged by law in the agencies. And the Office of Personnel Management and DOJ can't tell the agencies to do that, can't order them to do it. The theory before the MSPB is this was not really a decision to fire individual probationary employees because they weren't working out, which is the ordinary reason to let go probationary employees. It was really a RIF, and it was an across-the-board effort to reduce the force, a RIF, and the RIF procedures had not been followed. So we understand that as a result of all these actions, the agencies have largely reinstated the probationary employees who were fired during that first wave in February. Now, that doesn't mean that subsequent actions can't be taken. That is, they can be released for proper grounds. If a decision is made by the proper entity, their agency, they can be subject to a RIF. But at least the first set of firings of probationary employees has largely been reversed by the agencies. That's working its way out, and we understand that in some places that hasn't happened, and in some places people have been reinstated without back pay. But it appears to be at least that the initial wave is being reversed. So if I can get the next slide, let me drop something into the chat here. So one of the firms that is working with a set of others on these class MSPB appeals is a firm called James and Hoffman. And if you go to what we're about to drop into the chat, there's a link which has a very good summary of which agencies have class appeals pending for probationary employees and also the current status.
And Craig, that might be a question. I'm going to anticipate a question that folks might have. If a class action is already filed, do you know if federal employees can join the class action currently as long as it's still pending in front of MSPB?
That's a good question. And the answer is you don't have to do anything. So if you go to the link and you see that your agency is already subject to a class action, say the Department of Energy, and you were fired in that initial wave in February, then there's nothing further you have to do. Right? The filing of the class action protects your rights. That is the statute of limitation, the time you have to file your own appeal does not run, and you're protected by the class action. So there's nothing you need to do. If in following this, you find out later the class status was denied, or you're outside that period, that is, your probationary employee was fired later, then you may want to explore exercising your own rights. But if you're in one of those classes and you were fired in that initial wave, then there's nothing you need to do right now, other than follow the litigation. So the next step the administration took, and this one is still ongoing, is the creation of a new schedule for federal employees, which they've called this time Schedule PC, standing for Policy Career. You may remember at the end of the first Trump administration, they created something called Schedule F. And Schedule PC is just Schedule F, come back to us. It was Schedule F, the Trump administration in its first go round tried to do this very late. And when President Biden was elected, he revoked the executive order and went through notice and comment rulemaking to revoke the rules. So what is this? The executive order and proposed rule create a new schedule in which the incumbents will not have just cause protection or appeal rights. So the argument from the administration is that people who play a policy-making or even policy-influencing role should be removable at will, because they otherwise, in many instances, the administration argues, frustrate the will of the president and the policy that he wants to implement. And if they do that, they should be removable at will. So the incumbents will not have just cause protection or appeal rights. The regulation proposes, the executive order and the regulation propose that the agencies will identify positions that should be moved into this new Schedule PC. OPM will approve, and the ultimate decision will be the president's to designate the positions to be moved. There is pending litigation already about this, I think 4 or 5 separate cases. No action has taken place on them yet because the proposed rule is still at the notice and comment stage. So comments are due actually on Saturday, and then we expect OPM to issue the rule, and then positions will begin to be moved through this process, agency to OPM to the president. It will be challenged. It will be challenged across the board. As I said, 4 or 5 cases already pending, and there will be a challenge if incumbents are moved as to whether the rule can strip an incumbent of those protections. So you're already in a position, and your agency decides to move your position into this new Schedule PC. Can that effectively strip you of what you now enjoy, which is the ability not to be, or the right not to be fired without just cause, and the ability to appeal that to the MSPB? So there'll be litigation across the board, and there'll be litigation challenging any attempt to strip existing employees through the reclassification of their position into this new schedule. So we have the next slide. In order to strip federal workers of one defense against these actions and others, the Trump administration has also taken several actions to strip them of their right to collective bargaining. And this, of course, is part of a broader effort to attack all the institutions of civil society which are resisting the administration. Unions, universities, the press, law firms, all the institutions of civil society which can provide resistance are under pressure by this administration. So first action, President issues an executive order excluding what we believe is about 2/3 of the workforce from collective bargaining on national security grounds. Now, there is a provision in the collective bargaining statute which provides the president with the authority to exclude agencies or parts of agencies on the grounds that the agency is involved in national security and collective bargaining threatens that function. It's been used very sparingly in the past. Presidents have used that authority, but to exclude very small portions of the workforce clearly involved in national security matters. On March 27th, President Trump issued an executive order, as I said, excluding up to 2/3 of the workforce from collective bargaining, including the IRS, the Bureau of Land Management, all of the EPA, et cetera, et cetera. Interestingly, in an order which purports to exclude based on national security, it does not exclude Border Patrol agents. Why, you may ask? Because Border Patrol agents union has been supportive of President Trump. Unless there be any mistake about the motive, the White House fact sheet on the order states, quote, certain federal unions have declared war on President Trump's agenda. The largest federal union describes itself as fighting back against Trump. It is widely filing grievances to block Trump's policies. So you now have, I think, 4 pieces of litigation challenging this executive order. You had an initial injunction, as we talked about, halting the order issued by the District of Columbia District Court. That order has been stayed by the Court of Appeals. But as I say, 4 different actions pending, alleging both overbreadth. That is, you can't possibly argue that these agencies actually have a national security function and that collective bargaining would somehow impair that function, and of First Amendment grounds. That is, this is retaliatory. It's not attempting to actually protect the national security function of these agencies, but retaliate against the unions for their protected activity opposing the administration's policy. The second action by the administration related specifically to the TSA. TSA is governed by a different statute, and the authority to grant or revoke collective bargaining rights rests with the in a different place, not with the president, but with the head of the National Department of Homeland Security, excuse me. And she revoked the collective bargaining rights. That was challenged in the Western District of Washington and has also been enjoined, again, largely on First Amendment grounds. So what are the common themes here before we step back and talk about how you can keep track of all this? So I think you see the common themes. One is the centralization of power in the president. So in almost all of these cases and in other actions, the theory behind the executive's action is that there's a so-called unitary executive. The president has authority under the Constitution to take care that the law be faithfully executed. And this president says, in order to do that, I have to have authority to control the entire executive branch. So he has, for example, fired the heads of so-called independent agencies, National Labor Relations Board, the Merit Systems Protections Board, and all the way down to alleged policy influencing employees. That's the proposed Schedule PC. So the administration is saying the president has to have authority all the way down to fire people at will in order to take care that the law be faithfully executed. And then correspondingly, of course, a demand for loyalty to the president. So you have a loosening of restrictions under the Hatch Act. Right? Previously, you couldn't display political paraphernalia in the workplace. So you couldn't be identified as supporting the president politically or opposing the president politically. But the new special counsel has revoked that rule under the Hatch Act. And then finally, and unfortunately, the use of incivility and humiliation as a tool. So, the way that you all have been treated is a tool to effectuate these policies as much as all the rifts and changing of schedules, et cetera, are. So let me stop there and just say, how do we keep track of all this?
I think you've given them a tall order here, Craig, in terms of all these different, and we do have quite a few questions on the lawsuits too. So maybe after you get through that, we'll pause and ask a couple questions.
Yeah, so this is hard to keep track of. There's a lot of litigation. It's fast moving. So two suggestions, and we'll drop both in the chat. One, there's an organization called Just Security, and it's got a very good and up-to-date tracker. It's more broad than employment. It covers all the actions against the administration, so immigration actions, et cetera. But it's a very good tracker and keeps up to date. So we'll drop that into the chat. And then the organization I'm going to talk about, Rise Up Federal Workers Legal Defense Network, we also have up, or will have up in the next day or two, a tracker limited to cases involving federal employment, which will also keep updated at least on a weekly basis. So it is a lot, but those are two places in which you can keep track of it. And as to the federal litigation, you should keep yourself abreast, but there's really nothing that you can do or have to do, right? That is, if you're covered by one of these actions, say the case involving whether the president can reorganize the government, you don't have to do anything to join the case or not join the case, right? The plaintiffs are seeking relief across the board, nationwide, for all the agencies, against all the agencies that are named. So of course you want to keep yourself up to speed on what's going on, abreast of what's going on, but there's no action that you need to take as to the federal court litigation.
And I think, Craig, that's a point that speaks to some of the questions I've seen is folks are asking, like, when can we go back? What happens? What does this mean for me? And my takeaway from what you've said, which is the unfortunate piece, is that these court cases, depending on, the length of an injunction or depending on a final ruling, it could be a long time. And so federal employees who are parties to these suits or covered by these lawsuits might not see a change to their personal status anytime soon. Am I reading that correctly from what you said?
Largely. I mean, there have been some discrete actions that the government has taken to comply. So as to the first wave of probationary employees who were fired, they should have been reinstated now with back pay, and we know some have. The big reorganization case, we understand most agencies have now informed employees who had previously been told they'd been riffed as of this week, that's on hold. In many cases, they haven't reinstated, but they have put the RIF on hold, so people are still being paid. But as to a final decision, which is going to permanently reverse any or all of this, it is unfortunately quite a ways off, right? We don't expect the government to give up easily. We expect many of these cases to go to the Supreme Court, and a final decision by that court is certainly deep into probably next year.
That's right. Another question that was asked that I think is interesting is some folks are asking about what should employees do if they're seeing agencies not follow court orders, or if there is an injunction or there is something and they're seeing agencies not do that. Does that become a whistleblower case? Is it something they should go to the Federal Workers Legal Defense Network with? Do you have any thoughts on where those sorts of issues rise up to?
That's a good question. And I think, unfortunately, a whistleblower complaint given the current occupant of the Office of Special Counsel is not productive. But if there is an order, so for example, you're in one of the classes of probationary employees, you understand that the agency is putting back those probationary employees and you haven't been put back, you ought to try to contact counsel, right? It's up to counsel in these cases to bring the court's attention to non-compliance, right? So we understand, for example, that there's issues of non-compliance with the order on the reorganization case in certain departments, state and HUD, for example, and that counsel is raising it with the government's counsel and potentially with the court. So if you're fairly sure that there's an order and your agency is not complying, the best place to go is counsel. And with trackers, you can figure out who counsel is and potentially communicate.
Great. One other question, clarification on some of these things, and it kind of speaks to that, is whether for those of folks who are about to be RIFed or have been RIFed, should they sit and wait for one of these cases? And I think the answer is no, because they're so long, the class action cases and others, or should they go talk to an individual attorney and potentially seek to file something at MSPB? And that might be a good segue into the Federal Workers Legal Defense Network, which is where folks can find answers to some of those questions, because they are an individual circumstance.
Yeah, I think actually my next slide talks specifically about RIFs. So let's look at that for a second. So, this is what's happening right now, as many of you know. There is federal court litigation, as already described, both the case involving reorganization and the department by department litigation. There's also a set of union grievances, of course. That is, people who are covered by, are represented by a union, and therefore by a collective bargaining agreement. The unions have filed grievances concerning the RIFs. How do you figure that out? So if you go to this site, we'll drop in the chat in a moment, or what's on the bottom of the screen, workerslegaldefense.org, and you ask for help, you will take a brief survey, and it will enable you to figure out if you are represented by a union, if you don't know already, how you figure it out, where it's listed on your SF50. And we also have a complete list of points of contact. So you'll be able to figure out if you are represented, you'll be able to figure out how to find your collective bargaining agreement, and you'll be able to figure out how to contact the union in order to figure out if the union has filed a grievance concerning the RIF. You also, as Jenny said, may have a right to appeal to the MSPB. You should know that has to happen within 30 days of the effective date of the RIF. So you have a very short time frame, even though the agency currently at the highest levels is non-functional. But you have to file within 30 days. Now, that's from the effective date. So it's not from when you get notice, it's from the effective date. Right now, the agency is overwhelmed. The average number of weekly appeals in normal times is about 100. In the first 2 weeks of February, it was between 1,000 and 2,000. So the agency is overwhelmed. It's still functioning, but it's overwhelmed, and cases are going to stall there for some time because they can't be decided by the full board because the board lacks a quorum. Good news is there is an appeal right once the board decides the case to federal court, the federal circuit. So there is an appeal right once the case is decided. So what should you do? That's a very hard question. I think the best thing to do is talk to your peers, right? The bar is the federal employment bar is very busy right now. So if you can talk to your peers in your workplace, who have been riffed, who have a common set of issues about the riff notice and what it said and what it didn't say and the process for the riff, and come as a group to counsel, you're going to be in a much better position of getting counsel and filing as a group. Because it's right now, to be frank, it is hard to find counsel, and everybody is extraordinarily busy. So if you can organize yourselves and come to counsel as a group, that'll be that'll be helpful. So how to get counsel? Let's go to your next question in my next slide. A couple different ways. So the AFL-CIO, together with a number of partners, Partnership for Public Service, Democracy Forward, which has been involved in a lot of litigation, our major federal sector unions, AFG, NFFE, NTU, and others, created this organization, Rise Up Federal Workers Legal Defense Network. And we did it for exactly the reason we've been talking about. That is, there is a lot of litigation going on, but we don't know how it's going to turn out. And a lot of people don't know what to do in the interim. I've been reinstated. I've been unreinstated. I've been given a RIF notice. A RIF notice is stayed. I don't know what's happening with my health insurance. I don't know if I should retire or not retire. All those questions need answers. And so we created the Federal Workers Legal Defense Network to essentially expand the pool of people who could answer those questions. Right? That is, as we said, the very specialized but very good federal employment bar, people who do this year in and year out, were quickly overwhelmed. So we've trained upward of 1,000 lawyers to provide counsel. And we have a website, and that's the website, where you can go and ask for help, and where those lawyers can go to volunteer to give you that help. And what will happen is you'll be matched with a lawyer for an initial screening, just to figure out what your question is. If it's a question we can answer based on material we have up on our website, if you need a more specialized lawyer, or to be referred to an up to 1 hour consultation. So a brief screening and then up to a 1 hour consultation, all pro bono, all for free. Now, given the demand, I can't promise this will happen tomorrow, right? There is somewhat of a wait. On the other hand, when you go to our website, you'll find a whole set of materials which may answer your questions. And Jenny and the partnership have materials up as well. Civil Service Strong, which is part of Democracy Forward. Those are 3 places to go to get guidance on all these issues while you seek counsel. So we will attempt to put you in touch with counsel as quick as we can. We've also held a number of town halls just like this one, addressed to specific issues. We had one for probationary employees. We're going to hold several others, which are department or agency specific. So we'll try in every way to get you the information you need. 2 other sources of help, and we'll drop the links into the chat. If you are an employee of the Department of Justice, an organization has been formed called Justice Connect, specifically intended to provide assistance to DOJ employees. So as of today, they also have legal assistance available. So if you go to that site, Justice Connect, there'll be a link for you to again, request legal assistance. So if you're a DOJ employee, that's the best place to go. As to just finding lawyers who are experts in federal employment, the National Employment Lawyers Association, which is one of the partners in Rise Up. If you go to their site, NELA, National Employment Lawyers Association, they've got a Find a Lawyer button, and then they've got a specific list of lawyers who do federal employment work. So those are 3 sources. But as I said, particularly as to RIFs, this is going to be an avalanche. And the best thing you can do is gather together with your coworkers as a group, look at what you've been given, the RIF notice, talk about what the flaws are in the notice, in the process. If you look at the guidance in all the places we've suggested, you'll know what to look for, and then go as a group to one of those places to seek counsel.
And Craig, that's where we see some of those class action suits, is exactly that, where there's a group of folks with similar legal challenge. And that's, and those can move again through MSPB. There might be class actions other places. So I think that's certainly something that folks can look at.
Exactly. So many of the mistakes that are being made are not being made by an individual. Some are. They may have made mistakes in the RIF notice as to where you should be ranked in the retention register. But many of the mistakes in terms of whether there is a retention register, how the competitive area or the competitive levels are defined are applicable to a group. So if that's true, organize yourselves and come as a group to counsel.
And that's, I think, again, that's where figuring it out, because there are so many different situations here and it depends on agency, depends on office. So again, people need to ask those questions and have those conversations. I know we're getting close on time, but I do have one final question that that came in through the chat about the RIFs that are on hold right now. If there's an injunction on a RIF and then the lawsuit ends up in favor of the government so that the RIFs can proceed, would that mean the folks, if it was, if it had been an injunction, would all of a sudden they be immediately terminated again because that moved forward? Or would they still go through a notice process? I guess we don't know what agencies would do, but would any sort of appeals or other things be on hold as well?
Well, the current status is there is an injunction. The stay request in the Court of Appeals has been denied, so the injunction is still in place. There's a request for stay at the Supreme Court. Well, let's imagine a week from now, the Supreme Court says, we're staying the district court's order. That is, we're saying the district court's order is no longer in effect. I think you have to expect that at that point, the agencies are going to say, the stay is gone, or the injunction is gone. The RIF notice has already been given. 60 days have already been passed. You're RIFed. We would argue that the 30 days to file your appeal doesn't run until the action is effective, right? So that this injunction has stayed that 30-day period to file an appeal. But if the agencies take the position, which I think we have to assume they will, that if the injunction is stayed, the RIF goes into effect immediately, I think we have to assume that people will effectively be RIFed as of that date.
And I think that's a good reminder of something you said earlier, Craig, which is folks need to really keep track of these legal suits that are going on, because you're going to want to know when some of those actions happen, because it might set the clock ticking. And so staying on top of those trackers that we popped in there and other trackers will be helpful. I do want to make sure, since we are almost at time here, to let folks know that we typically do a quick survey just on the session and ideas for future sessions. And so my colleague Shirley will put a poll up there for the folks on the line here to see. And then we will certainly love suggestions for topics, what's on folks' minds, because that's obviously continues to be a lot of questions and a lot of activity. It's very hard to keep on top of everything. Craig, you and I were talking about that. Like, there's just so much that happens at such a fast pace that we're hoping, Rise Up, like you said, partnership, Civil Service Strong. There are a lot of places that are trying to bring this information together in one place. So obviously at FedSupport.org, and you've got the workerslegaldefense.org. And so I do want to thank you, Craig, for coming on. This was extremely helpful to see everything in one place and sort of get a sense of the landscape. So really appreciate you being here and doing this. And certainly we'll share more information about Rise Up as it comes out, and then any of the things that you all have that we can share with our viewers.
My pleasure. Thank you.
That's great. And for everyone else on the line, thank you so much for listening in. Thank you again for the service that you provide through your agencies to this country, and really wish you all a good evening.